Good evening, ladies and gentlemen. A warm welcome to each one of you. It's my privilege to introduce you to the launch of Continuing Legal Education Program of Kerala Federation of Women Lawyers to be held on a virtual platform. We hope to introduce you and discuss topics of current relevance in this series. Justice Anu Shivaraman, our mentor and supporter, has a message for us which sums up the objective of this series. I shall read to you the message from Justice Anu Shivaraman. I'm so happy to see that the Kerala Federation of Women Lawyers is embarking on an online lecture series on legal topics as a part of its continuing legal education program. The legal profession involves an unending education process, and each day requires fresh information and knowledge. It is in the honing of skills and in the building of competence as lawyers that success depends. I wish this venture all success and hope that all women lawyers and other lawyers as well utilize this opportunity to augment their competence and performance. Wish you all the very best. Thank you, Justice Anu Shivaraman, for this message on the launch of our ongoing legal education program. Now, it's my pleasure to introduce you to the speaker of the day, Ranjita Jason, a postgraduate in law. She enrolled in the year 2000 and started her practice under the able guidance of late barrister M.P.R. Nair. She was a government leader from 2018 to 2020. She served as a member of the Executive Committee of the Kerala High Court Advocates Association, presently a member of the Executive Committee of Kerala Federation of Women Lawyers. She is an active member of the Victim Rights Center attached to the High Court of Kerala. Maintaining a wonderful work-life balance, she is a mother of 4 lovely girls and a well-honed lawyer. Thank you. Over to you, Ranjita, for the session.
Thank you. Thank you very much. I am really grateful to be a member of KFWL, the organization which have given birth to eminent legal luminaries to the legal fraternity. And I am really proud to be member of the KFWL. We start with the class, Euthanasia, mercy killing. No, not mercy killing. I start with the words of Justice Achu. I request please to mute the mic who are. Okay, thank you. I start the class with the quotes, words by Justice Kadju, which has been started in the Aruna Ramachandran Shane Bang's case, which is considered as the landmark judgment in Utenasia. The lines of Mirza Ghalib, it goes like this. मरते हैं आरज़ू में मरने की मौत आती है पर नहीं आती. So this is a beautiful line of Mirza Ghalib. Now I start up with this. Now I would like to screen share. May I get the help of Kaveri?
Yes.
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 Are you able to see this screen?
Yeah. Screen sharing is happening.
Okay. Okay. Fine. Thank you. Now, yes. Now I've subdivided the topic Utenasia into 9 subdivisions. or speedy referral. Now, euthanasia's definition. The definition of euthanasia, the legal philosopher Sir Francis Bacon coined the phrase euthanasia from time memorial, that is from 17th century. Euthanasia is derived from the Greek word eu, meaning good, thantos meaning death, and early on signified a good or easy death. So euthanasia is defined as an administration of legal agent to another person, to a patient, for the purpose of relieving patient's intolerable and incurable sufferings. Typically, physician's motive is merciful and intended to end the suffering of the patient who is undergoing pain. So that is the definition given by Francis Bacon from the 17th century. Now we are in 22nd century discussing the legal sanctity of euthanasia in India. Now we pass on to the historical background. So the evolution of euthanasia is very important as far as we discuss the legal sanctity of euthanasia in India. Historical background, according to historian N.D. Kemp, the origin of contemporary debate on euthanasia started in 1870. So the euthanasia was practiced in ancient Greece and Rome. Hemlock was employed as a means of hastening death of island of Kea. We have gone through the Shakespeare's poems and dramas, plays. We find the hemlock, suicide, the euthanasia were more acceptable under Protestantism and during the age of enlightenment. For example, in Japan, suicide has not been traditionally been viewed as a sin. And accordingly, the perception of euthanasia are different in Japan from those in the other parts of the world. Now, we are all very well aware of Nazi genocidal policy. What was actually Nazi's policy? The Nazi euthanasian, that they want to wipe out the Nazis. So that was national policy of them. A life unworthy of life. Next, ancient Indian philosophy. Now we come on to the ancient Indian philosophy. What was happening contemporary at the time of India at that time? So Hindu mythology, we see that Lord Rama took Jal Samadhi in Sarayu River, and we have Lord Buddha, Lord Mahavira. How did they attain death? They stopped intake of food. They starved themselves to death. So whether that was a suicide or whether that was an euthanasia, a mercy killing of oneself, attaining, how can we define that? These are all questions which are being answered through our session. So the ultimate goal of moral life is to achieve moksha, or liberation from the cycle of death and rebirth. Thus, trace of right to die existed in earlier times also. Next. Now we think about the world perspective. What was the world perspective of euthanasia? We take the Australia. Northern Territory of Australia became the country to legalize euthanasia by passing the rights of terminally 3 Act 1996. It was held to be legal in the case of Wake versus Northern Territory. The Australia Supreme Court of Australia. Euthanasia law was enacted in the year 1997. But basically, people when think about euthanasia, the Netherlands come to our mind. But Netherlands, subsequently only Netherlands comes. First, it is the Australia, because the Euthanasia Act 1997 was enacted in Australia first. Now, when we see Albania, legalized in Albania in 1999, and form of voluntary euthanasia was legal under the Rights of Terminally Act 1995. So, and next, it was in Belgium also, it was legalized in 2002. In Netherlands, it was the first country to legalize both euthanasia. That is the reason we used to, Netherlands used to come to our minds, because in the Netherlands, both euthanasia and assisted suicide in 2002 was legalized. According to the Penal Code of Netherlands, killing a person on his own request is punishable with 12 years of imprisonment or fine, and also assisting a person to commit suicide is also punishable by imprisonment up to 3 years of fine. So the court have to interpret the law as proving a defense to change the voluntary euthanasia and assisted euthanasia. This is something similar to our Indian law also, because during the course of discussion we would see why I said we have some similarities with Netherlands. Next is Canada. Supreme Court of Canada gave importance to the wishes of the patient, and if the consent should be validly obtained by the doctors or not. So these are where all questions contemporarily discussed throughout the world before euthanasia was legalized in India. Next, Euthanasia Classification. So these are all terms used. I'm explaining all these terms so that when we are discussing the case laws, it becomes easy to understand the terminologies used in the case. But that is the reason it was subdivided in such a way for our understanding. So classification of euthanasia, voluntary euthanasia. Voluntary euthanasia is conducted with the consent of the patient. Non-voluntary euthanasia, where the consent of the patient is not available, non-available, because when a person is in a vegetative mode or in a coma, how can that person give consent? So that is non-voluntary euthanasia. Involuntary euthanasia, conducted without patient's knowledge and consent, permanent vegetative state, that is PVS, coma or brain damage. These are all terms which has been discussed in depth in Aruna Ramachandran Shenbang's case. What is passive euthanasia? Withholding life support means. That is, if a person is breathing with a ventilator, machine supporting the breath, removal of that machine is passive euthanasia. And stop feeding that person, or stop feeding or stop giving some antibiotics to that patient. That is passive euthanasia. Now, what is active euthanasia? This is illegal throughout. Only 2 or 3 countries are accepted the active euthanasia. Active euthanasia, use of legal substances or forces, such as administering a lethal injection. An injection is directly given to the patient on the spot. That patient is within a 5 minutes of time, that patient ends their life. Very recently, we have seen in Colombia a person have under an implementation of active euthanasia. We have seen very recently, which was in news. Next, concept of euthanasia in ancient India. So we are on the way of evolution of euthanasia to reach the legal sanctity. What are all evolutions which took place in the field of euthanasia has been explained over here. Now, concept of euthanasia in ancient India. Ancient Hindu philosophy also justifies the idea of willing death. As I said earlier, Jal Samadhi, Lord Rama and Lord Buddha, Lord Mahavira refused to take food. What is Johar? It means that self-sacrifice, self-immolation. Ladies of royal family, in the fear of attaining some insult or something of that sort, they used to sacrifice themselves. That is called Johar. And Sati, as we all know, what is Sati? Burning herself by the peril of her husband. So is this a euthanasia, or is this suicide? These are all things which happened in ancient India. How do we define all those things? Samadhi, termination of one's life by self-restraining on breath. That is what we discussed earlier, passive euthanasia. Removing the respiratory or ventilators from the patient so that they cannot breathe. So that is passive euthanasia. So now we are discussing about euthanasia in ancient India. So that is what is Samadhi, termination of one's life by restraining breathing. Atma Arpana, self-sacrifice. When do a person self-sacrifice themselves? They think that they is completed. My life is over. I have done everything. My life is complete, full. Then they think about Atmarpana or self-sacrifice. Is that suicide, or is that mercilessly killing oneself for their moral or religious sacrifice? So these are all questions which come to our mind when we think about euthanasia. Next, we pass on to our legal questions, which has been discussed by the apex court. That is, first we go on to Retinal versus Union of India, 1994, 3 SCC 349. And then comes Gyan versus State of Punjab, 1996. Aruna Ramachandra Shenbong, a landmark judgment of euthanasia that comes on 2011, which is reported in 4 SCC 544. Now, Common Cause versus Union of India is another case which is on 2014. That was referred to Constitutional Bench. That is again comes upon the 5th Common Law versus Union of India 2018. So that is the case where passive euthanasia was legalized. Now we start to discuss each and every case laws. Now we will start with Retinal versus Union of India. It was a division bench of Justice R.M. Shahi and Justice B.L. Hansaria. And Justice B.L. Hansaria delivered the judgment, which was elaborately discussed, and the distinction of suicide and euthanasia has been pointed out in this case. Now, when we go into the depth of this case, the 2 petitions were brought before this Honorable Supreme Court. And the prayer of the petition was very relevant. Validity of Section 309, contending that same is violative of Article 14 and 21. Now, when we say Section 309 of IPC, what is Section 309 of IPC? So, whoever attempts to commit suicide and does any act towards the commission of such offense shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both. So that is Section 309 of IPC. Now the question here is validity of Section 309 by contending that same is violative of Article 14 and 21 of the Constitution. And the prayer of the petition was to declare the section void. Now, the judiciary of this country has occasion to deal aforesaid aspect. Now, 3 High Court's decisions were taken. Delhi High Court, Bombay High Court, and Andhra Pradesh High Court. The Delhi High Court,
Arbitration Act
Delhi High Court.
Supposing there is a
The apex court have assailed the validity of 309. Now we pass on to Delhi High Court's decision, that is State of Sanjay Kumar Bhatia, 1985 2 DMC 153 DL. The division bench of Delhi High Court, headed by Justice Sachar, Section 309, no justification in continuance to remain in the State 2 book. That was the decision. Now I will just brief out the facts of that case. Was a boy has attempted to commit suicide. No, but he failed in his attempt and he was penalized. So the Justice Sachar speaks out that instead of sending the boy to psychiatric clinic, it's gleefully sent him to mingle with criminals. Now, when does a person commit suicide? So when he attempts suicide, that means something has happened in his life. He thinks that he is not able to overcome that position, overcome that situation. That is the reason he has attempted to commit that suicide. So what we do is, going by 309 of IPC, we will charge him and we will put him to, we will be penalizing him under Section 309 of IPC. Now, is that correct? That is what Justice Sachar said. No, these people have to be handled with very care. So the very idea is revolting. The concept seeks to meet the challenge of social strain of modern urban competitive economics and ruthless suppression of mere symptom. This attempt can only result in failure. Therefore, Section 309 IPC should be declared unconstitutional, or it should be, there is no justification in continuing in the statute book. That is what Delhi High Court Justice Achar have said. Now then we move on to second, that is Maruti Sripati Dubal was a state of Maharashtra, 1986, the division bench of Bombay High Court. Now let us examine what the Bombay High Court has said. Bombay High Court has said that on being approached, the quashing a prosecution launched against the petitioner, Section 309 of Indian Penal Code on the ground of unconstitutionality. That is, this Bombay High Court says that it's violative of Article 14 and 21. Therefore, it has to be struck down. Now, what is Article 21? Right to life. Does right to life include right to die? So that was the concept when this judgment was pronounced by Bombay High Court. Right to life. So therefore, it is said that Section 309 of Penal Code is unconstitutional and it is violative of Article 14 and 21. So that was the decision taken by Bombay High Court. And now we pass on to Andhra Pradesh High Court. Chenna Jagadishwar versus State of Andhra Pradesh. Section was valid. Now it is a dissenting statement made by the Andhra Pradesh High Court. The bench held that section was valid as it did not offend any of these articles, Article 14 and Article 21. So the Bombay view was descended in this Andhra Pradesh High Court's judgment. Now, the apex court further dissected and dissected these judgments, and distinction between suicide and euthanasia was brought up by referring to the Supreme Court of Nevada, the state in America. A case where Mackay versus Braxis patient filed a petition to disconnect the respirator. The patient himself files a petition to disconnect his respirator, that is the ventilator system. He says, no, stop, I don't want to leave. Everything is enough, I don't want to leave. So he gave a petition and that petition was heard. The district court allowed his petition. That was brought to the Supreme Court of Canada. Supreme Court took the view that desire of the patient for withdrawal of his respirator did not tantamount to suicide. The same was rather an exercise of his constitutional and common law right to discontinue unwanted medical treatment. This was majority view. One dissenting view was there. I emphasize on this decision because this decision, the decision of Supreme Court of Nevada, that is in America, that was mentioned by our Supreme Court in upcoming judgments. So this decision becomes very relevant. Now this court framed 16 questions before defacing Section 309 of IPC. 16 questions were put forward. Now the question is, Article 21, any positive content? Has a person residing in India right to die? There are a series of questions put forward by the Honorable Supreme Court. And finally, it has come to the conclusion that Section 309 of the IPC Section 309 of IPC has to be discontinued from the statute book. So, which is unconstitutional and hence void. So that was the decision taken by the Supreme Court in Retinal versus Union of India's case. Now, next we pass on to next judgment is Gyan versus State of Punjab. That was the case which took place in 1996. That is here the discussion was in Section 306, abatement of suicide. Now, when we say abatement of suicide, we ought to know what is Section 306 of IPC. If any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Again, I have explained Article 14, Constitution states that shall not deny to any person equality before law or equal protection. We all know Article 21, no one shall be deprived of his life or personal liberty except according to the procedure established by law. Now, the issue raised in this petition was whether the section 306 of IPC constitutionally valid. Whether section 309 IPC violates Article 14 and 21 of the Constitution. Because earlier in Retinal's case, we said that it is violative of Article 14 and 21. Therefore, 309 of IPC is unconstitutional. That was held. That was in the year 1994. Now this is 1996. In 1996, Supreme Court evaluates. When the question comes about the section 306 of IPC, at that time, at that spur of moment, this discussion was also put forward. 5-judge constitutional bench was held that right to life is inherently inconsistent and convenient with the right to life under Article 21 of the Constitution. I would like to just sum up the brief the cases. In this case, the husband and wife was penalized under section 309, under section 306 by the trial court. And husband Gyan Kaur and her husband Harbhajan Singh were charged and committed the offense abatement to suicide of their daughter-in-law. That was the case. Now they appealed to High Court. Appeal also reiterated to the trial court, and then it comes to the specially petition come to the Supreme Court. Now Supreme Court have raised 2 issues that I've said earlier: whether section 306 of Indian Penal Code is constitutionally valid. Second one, whether section 309 of Indian Penal Code violates Article 14 and 21 of the Indian Constitution. So in this case, as I said, Article 21 and 14 is also involved. Now the contention raised by the petitioner counsel is that it should be, that is, contention was that section 306 of Indian Penal Code should be held unconstitutionally invalid. Why? Because in Retinal's case, in 1994, Supreme Court has held that section 309 of IPC is unconstitutional. Therefore, 306 has to be held unconstitutional. That was the contention put forward. And next comes the counsel on the petitioner further contends that animal extincts, but right to live without human dignity and embracing the quality of life. So that is, they wanted to bring the right to life, that is right to die, into the ambit of right to life under Article 21. That is the reason these sort of arguments were put before the honorable court. That is the reason they say animal extincts, but right to live with human dignity. What do you mean by human dignity? Human dignity means a person who is in a vegetative state. He has a person who has lived his life throughout in a very, very excellent way, but now he's on bed, but he's conscious, but he says, no, I want to end up everything. That is the reason they wanted to compare or imbibe with the right of right in Article 21, right to life, right to die. They want to imbibe into Article 21. Okay, then the counsel appeared, then and contention, the respondents, what was the respondent raised was the right to life is inherently inconsistent and contravention with the right to die. Thus, right to die cannot fall within the ambit of Article 21. So that is the reason, that was the contention raised by the respondent. The respondent says that no, it cannot be brought into the ambit of Article 21. Now, when the court pronounced the verdict, the constitutional bench thinking loudly says that right to life is inherently inconsistent and inconvenient with the right to die, as death with life. So the court held that right to die cannot be imbibed or compared with right to life. The court observed that right to life under Article 21 of Indian Constitution does not include the right to die or right to be killed. right to be killed because we are on the topic euthanasia, mercy killing. That is the reason it was said right to kill. Now, therefore, the contention made by the petitioner on making section 309 IPC unconstitutional, violative of Article 21 of Indian Constitution cannot be accepted. So therefore, the Supreme Court held that right to life does not include right to die. So therefore, the prior decision in Retinal's case, it was held that section 309 is unconstitutional. Now here, the Supreme Court again finds out that, again made a decision that in P. Retinal versus Union of India was struck down the Supreme Court, making section 306 and section 309 Indian Penal Code constitutionally valid and making the accused person punishable for the offense committed under these sections. So this is very important because in this case, Gyan Kaur's case, Supreme Court have overruled the decision taken in Retinal's case. In Retinal's case, section 309 of IPC was held unconstitutional. Now this is a constitutional bench. In 1996, the Supreme Court have again held that section 309 of Indian Penal Code constitutionally valid, making the accused person punishable for the offense committed under these sections. So that was the decision which was taken by Supreme Court in Gyan Kaur versus State of Punjab. That was in 1996. To conclude with, India being a welfare state is more focused and determined to protect the life of its people. So that was also another reason not to struck down section 309. Furthermore, the decision in this case manifests that individual's life is more important and emphasized more on leading a life in dignified manner. So that was a reason given by Gyan Kaur versus State of Punjab in 1996. Next, we pass on to another judgment. That is the landmark judgment of this topic, today's topic, burning topic, euthanasia. Aruna Ramachandra Shenbang versus Union of India. Whenever we hear about euthanasia, immediately a picture comes to our mind of Aruna laying in a hospital. Skinny lady laying in a hospital. So this was a incident. This was the case which was registered in 2011, and it is reported in 2011 4 SCC 454. Active and passive euthanasia was explained by the court. As at the beginning of the session, we have all seen what is active euthanasia, what is passive euthanasia. This type of euthanasia was classified and differentiated by the Honorable Supreme Court in this case, Aruna's case. Now, this is a very important case. I would like to take everyone to the facts of the case in short. The case is the petitioner Aruna Ramachandra Shenbang was a staff nurse working in King Edward Memorial Hospital at Mumbai. Now, one evening when she was only 24 years, one evening she was on duty. What happened was a sweeper of the hospital dragged a dog chain around her neck and yanked her back with it. He tried to rape her, but what happened was she was menstruating. So he didn't rape her. Then he sodomized her. While doing that act, what happened is, to make the body immovable, he pulled that chain which was wrapped in her neck as well as her hand. So at that time, what happened was the oxygen supply to her brain was blocked. There was where brain damage took place. Next morning, some staff found that she was flooded with blood. She was laying there. And then 36 years have elapsed since the said incidents. I again insist on the year. 36 years that lady was lying in a vegetative state in the at King Edward Memorial Hospital. And then when the case was put forward by journalist Ms. Pinky Virani, claiming to be a next friend of the petitioner. She was a frequent visitor to, people used to come to the hospital to see Aruna. So one of the visitor was the journalist Pinky Virani. She used to come to see Aruna, and by seeing her fate, she was very, she said she has to do something for her because she has suffered for long years. So that is the reason, that is the moment where this petition sprung up before the Honorable Supreme Court. Now the finding of the Supreme Court was very, very different. The Supreme Court, because when the petition came up, it was said that she was a bedsore, she was all sorts of different facts were stated in the case petition. So the court said that let a team of doctors means three eminent doctors were appointed by the court. The doctor's appointment means the central government was given, payment was given by the central government to stay, the flight charge, etc. Everything was given to these doctors. And these doctors were sent to study the medical history in detail. While they studied the medical history, they understood that she is not brain dead. Aruna was not brain dead. Now, what is brain dead and what is coma is also important. These are all medical terms which has to be understood when a case of mercy killing comes before the Honorable Court. Therefore, the Honorable Court thought that a medical team of doctors will be very eminent persons to answer these questions. So these persons went to the hospital where Aruna was laying, and when they recognized, she was able to open her eyes. She was able to open her eyes. And she was not responding, but then when a number of persons entered her room, more than 2 or 3 persons entered, she used to make some noise. That means somewhere else, somewhere she was responding. So she is not brain dead. And therefore, how can a person seek for mercy killing when he is not brain dead? And when she was given mashed food was given, and when some soup was given, her facial expression, her eyes would change. That means she liked that. And Supreme Court also found that the hospital authorities have very well treated this Aruna Shenbang for 36 years, very well treated. That treatment was applauded by the Supreme Court. Now, the issue raised in this case was when a person is in a permanent vegetative state, PVS, should withholding or withdrawal of life-sustaining therapies be permissible or not unlawful? So that was the first issue framed by the Supreme Court. If the patient has previously expressed a wish not to have life-sustaining treatments in case of rutile case, as we used to do today, in this time, we used to donate our organs or eyes before we have something happen to us. For example, we donate our eyes. In case of an accident, even organs were donated. So similarly here, if the patient has previously expressed a wish not to have life-sustaining treatments,
Renjita, you're muted.
I'm sorry. Now it's okay?
Yes.
Okay, thank you. Now, the third issue was, in a case a person has not previously expressed such a wish, if his family or next friend or makes a request or withhold or withdraw futile life-sustaining treatments. So these are the 3 issues framed by the Apex Court while deciding Aruna Shenbang's case. First one, when a person is in a permanent vegetative state. Second one, if he has previously given consent. Third one, if a person has not previously expressed such will, whether his family members or next friend or his well-wishers or beneficiaries can do that. So these 3 questions was put forward by the Supreme Court. Now, while analyzing these facts, this is where the Supreme Court have decided and given an elaborate discussions regarding active and passive euthanasia. I again repeat, active and passive euthanasia. Active euthanasia is nothing but injecting a person with a lethal injection, or that is actively given consent and taking is called active euthanasia. Passive euthanasia is nothing but withholding of medical treatment for continuance of life, or withholding of antibiotics, or removal of respiratory like ventilators, that has been already discussed. Now we pass on to, so another is voluntary euthanasia, with consent or without consent. For example, a patient suffering from cancer, he says that no, I don't want to live anymore. So that is called voluntary euthanasia. And non-voluntary euthanasia means that person who is in coma or a brain damage state, he is not able to respond. That is there, at that stage, it becomes non-voluntary euthanasia, right to die. Now, Supreme Court, as we have discussed all these cases, right from the right in the Bombay, in Retinal's case, 3 cases were discussed: Delhi High Courts and Bombay High Court and Andhra Pradesh High Court. Now, in this case also, the Supreme Court have discussed the Retinal cases also, wherein the state of Maharashtra in Bombay High Court said that section 309 of IPC is unconstitutional, which is against Article 2014 and 21. That was set in state of Maharashtra versus Maruti Srapati Dubail case. That was reflected in Retinam's case. Then the reliance of the was placed on the landmark judgment of Airedale NHS Trust and Plan. Now, what does this Airedale NHS case means? In that case, that was a landmark judgment of the English history. That is, in that case, he was given consent to remove the support system, including the food and water. So that is the reason it was held as landmark case. That case was also imbibed into the Supreme Court judgment in Aruna Chainbank's case. Next, we have already discussed about the Supreme Court of Canada, wherein the patient insisted for permission for removal of respiratory system. That was also discussed in this case. Now, the medical ethics in this case, Aruna was not able to give consent because she was in a vegetative state. Now, in this case, or now the Supreme Court also opens their eyes for moving globally. What is happening globally, which we have already discussed about Netherlands, Switzerland, USA, all other countries. So the apex court have gone into the core of the issue, searching every country's law and then imbibing it into the judgment. Now, the Honorable Division Bench of Supreme Court of India, comprising Justice Markandeya Khatju and Justice Gyan Mishra, delivered this historic judgment. The court opined, based on the doctor's report and the definition of brain death under the Transplantation of Human Organs Act 1994, Aruna was not brain dead. So it was considered that she was not brain dead. So therefore, the terminating her life was unjustified. One more aspect was that the friends or next friends or beneficiaries can approach for the terminating her life. In this case, in this petition, Pinky Virani was not an ex-friend. If the hospital authorities would have approached, it is the hospital authorities who is taking care of Aruna. If the hospital authorities have approached the consent before the Honorable Supreme Court or Honorable High Court, the consent would have been given. Now, the Supreme Court here, in this case, stated that a consent cannot be given. But the guidelines, that is parent patriae, the principle of parent patriae was put forward in this case also. What is parent patriae? Parent patriae is nothing but the court to prevent any misuse of the vested power. So this is, see, these are all guidelines laid by the Supreme Court in implementing euthanasia or mercy killing. That is, parent patriae means the court to prevent any misuse in the vested power to determine the termination of a life of a person. The person has to approach the court. The person means the person next friends, relatives or beneficiaries have to approach the court for getting consent, and the court will further appoint doctors, 3 eminent doctors, as we have seen in Aruna's case. These procedures will be formed and then that is the guidelines. Guidelines were formulated in Aruna's case. That is the reason Aruna's case is known as a landmark judgment in euthanasia. Aruna was denied euthanasia in the court, opined that the matter was not fit for the same. But in this case, it clarified the issues revolving around euthanasia and also laid down guidelines with regard to massive euthanasia. All side, the court also made a recommendation to repeal section 309. We would remember in Retinal case, it was repealed, and subsequently in Gyan Kaur's case, it was again, the repealing was again upheld. And now in Aruna's case, repealing was again, recommendation for repealing section 309 has taken. Next comes the common cause. Now, the importance of Aruna Shenbang's case in 2012 is guideline was formed by the Supreme Court. Guideline was formed by the Supreme Court for taking euthanasia. Next comes the judgment is common cause versus Union of India. That was in 2014. Whether issue was whether a will terminally ill should be able to execute a document or legally will and attorney authorization, that is before his when he is in a proper state, he would execute a document. Whether that can be executed or not, that was a question which took place in 2014. Now, but that the validity of euthanasia was discussed, and later that was referred to constitutional bench. Next we come to common cause versus Union of India 2018. That is the constitution bench. The 2014 case was referred to this bench. Now, right to die with dignity be included as a fundamental right under the folds of Article 21 of Indian Constitution. Right to live with dignity. Right to live with dignity as fundamental right has already been declared by the Constitution bench judgment by the Gyan Kaur's case, which we reiterate. Now, in this case, 2018 case, the Honorable, yes, common cause case. This is nothing. It is most pointing of leaving will and attorney authorization, as it was set in 2014 common cause case. This is a society register taking that when a doctor takes oath, what sort of oath they take? They take that we will save the life if any way we possible. That is the oath taken. So now the society questions that Hippocratic oath of the doctors. If the euthanasia is legalized, that is if the doctors take the respiratory system or doctors stopping the food and everything to the patient, does this oath come to be a Hippocratic oath? To save every patient's life was also in direct contradiction to the right to die aspect. In this case also, the Honorable Supreme Court have analysis all the cases which have been dealt with, right from Retinal to Aruna Shenbang's case. That has been emphasized in this judgment also. Now, what is the difference was that everything was discussed: active euthanasia, passive euthanasia. The main crux of this case was right to live with dignity. Now, whether right to live include right to die, that was the main question and crux in this case, that is common cause versus Union of India in 2018. Now, while discussing that, it was said that no, the part of right to die with dignity does not come under the ambit of right to live with dignity. That was the decision which was earlier taken. Now, the current law allows passive and subjecting it to certain particular terms and scrapped off concept of leaving will authorization. Rather, that is, I consider this something which is prudent and going with respect of time and condition in our country. The passage of time and same will be evolved. The most common thing that one would find in the corpus will be relation to swearing to give the best. With regard to that oath of the doctors, nothing can be done. It can be done that we, in relation to swearing, will give the best treatment. That can be the oath that can be taken. And while concluding this, The Supreme Court held that right to die with dignity is a fundamental right. I repeat, right to die with dignity is a fundamental right. Right from the beginning, it was said that no, but in the Retinal case, it was held that, Bombay High Court case, it was held that right to life includes right to die includes right to life also. The right to life, liberty is envisaged under Article 21 of the Constitution is meaningless unless it encompasses within its sphere individual dignity. So individual, when we speak about individual dignity, right to die also is imbibed. With the passage of time, the court has expanded the spectrum of Article 21 to include within the sphere individual dignity. Therefore, to conclude with, it is said that right to die with dignity as a fundamental right has been declared by the Constitution bench of the court in Gyan Kumar versus. So now the new dimension in Indian history that have took place is right to life and liberty under Article 21 of Constitution is meaningless unless it encompasses within its sphere individual dignity. Right to live with dignity also includes smoothing of process of persistent vegetative state with no hope of recovery. When passive euthanasia as situational palliative measures become applicable, best interest of the patient shall override state interest. Now, passive euthanasia, a legal reality in India. By 2018 Common Cause case, it has become legal reality in India. Guidelines was laid down in 2011 in Aruna Shenbang's case. To conclude with, we utter, when it's my suggestion, when we implement euthanasia, utter care should be taken to practice euthanasia to avoid the misuse of the enactment. And finally, I would like to conclude. I would like to conclude the session saying the epic movies song of Prithvi Raj Kumar's Joker, that is Jeena Yahan, Marna Yahan, Iske Siva Jana Kahan. Thank you. Thank you very much.
Thank you, Ranjita, for this wonderful, very well prepared exposure on this subject. Whether death is a right or whether it is the end of all rights is a question that is looming around us. So we have about 10 minutes now for open discussion. I mean, in case there is any specific question, we could ask the speaker to answer your questions.
May I ask one question, ma'am?
Yes, go on.
If I need euthanasia,
yes,
how can I approach a court, or how can I explain that? How can I get that remedy?
Definitely. That was what stated in Common Cause case. That was registered. That is that company, Common Cause company, has asked that question, that how to get. In Aruna Shenbang's case itself, it was said that a guideline has been framed. That is, if you are in a physically or proper state, you can have a will. Like when you donate your eye, when you are in a proper state, you can have a donation of organs. Similarly, you can, when I am in a vegetative state, please end up my life. You can register a will. That was embodied by the Supreme Court in 2018 Common Cause case. So that was very well said, and that if it is and at that time, our near friends or relatives can bring up this petition or this will before the court. That is, I have said that parent patry. It cannot be implemented as of. It has to bring up before the Honorable High Court, and a petition will be filed. That will be produced. That court will appoint 3 doctors and see the position of the patient, and whether they are satisfied, the euthanasia will be given. Otherwise, no. That was what it was taken place in Aruna Shenbang's case.
Thank you.
So probably, Ranjita, I would say like, as you were comparing the situation where when we are able to donate one of the organs while we are in our senses or in control of our senses, as we would say, when we give the consent for eye donation after our death or organ donation in case of our brain death. Now, a living will is what is contemplated. Am I right?
Yes,
When
yes.
you talk about the provision laid down by the judgment. So when would it not also bring in a situation where the will, which we normally consider, is a document that comes out only when the man is dead? In the common law or in the common use, it's only brought out or comes into force only when the person is dead. Now, are we not even tampering with the law relating to will when we take in the right to write a living will?
Yes, that was a very good question, because the will comes only after the person's death. Now here the Supreme Court have decided when a person is brain dead, he is not able to respond. He is virtually dead. At that time, that will comes into effect. That is the reason which was given by Supreme Court in common cause case. Regarding same question was raised in by the Supreme Court in that case.
So it probably conceives of a situation where every person who wants to write a will of whereby when one wants passive euthanasia to be employed in his case or her case, one would have to probably alert either a legal heir or someone very close. In these days, one cannot be sure of one's legal heirs, but at least someone very close that you have left a request for passive euthanasia, isn't
And
it?
that is the arena where Supreme Court says that parent patres, it cannot be implemented as such. As far as a will is considered, it is automatically come into force when a person is not there. But as far as euthanasia, that will is considered, it has to go to the court, high court first, and then the process has to go on. Then only we'll get the consent.
Probably we'll go back to the old days when we used to go to court for probating the will. Now we don't go to court to probate the will. To make sure the will is properly executed, etc., we go to court and get it probated to ensure that it is a proper and the last will of the person. So in a way, it's a sort of reassurance, making sure that the court is giving its seal of authenticity to the last wishes of the person, isn't it?
Yes.
So anyway, it is.
I have a question in the chat box. If a brain dead person, how can he make a will? That is a good question, because a brain dead person means a will has to be prepared when he is in a proper sense of manner. After that, he cannot make a will. As far as Aruna Shainbang was considered, she was unable to move. She was in a vegetative state. But at that time, that is where passive euthanasia comes into effect through our next friend. But then Supreme Court was very, very clear and made crystal clear that that misappropriation should not take place, because some person may have a lot of property with them. Then when they are in a vegetative state, they go for a legal, because if, they don't know how long he is going to be on the bed. Only after his death, they will evolve the property. So that should not happen. That is the reason that such a guideline, strict guidelines was formed by the Supreme Court in common cause case.
Any of the states in India framed rules on this aspect? Have you seen any?
No, not so yet. Far. Not yet, because it has to be legislative. The bill is pending before the legislature.
In Kerala? In Kerala?
No, in central government, the bill is pending.
Okay. I see. Because I read somewhere that somebody has introduced a private bill on this subject in Kerala. That is why I just asked, where is it pending? Okay. So since, I mean, is there any other question, or can we fold up for the day? I think, thank you very much, Ranjita, and we are very, very much pleased that we were able to learn so much in this last 1 hour. Thank you very much indeed. On behalf of the Kerala Federation of Women Lawyers, a big thank you to each and everyone who has attended this online session. Thank you very much.
Thank you very much.